Uh, Good afternoon, everyone. Can you all hear me?
Yes, ma'am. Good afternoon, ma'am.
Okay. Sorry for keeping you all waiting. I was traveling. Really sorry if I caused any inconvenience.
No problem.
We'll go into the class directly. Just a moment, I'll just share my screen. Can you all see the screen?
Yes, ma'am.
Okay. So today we'll be dealing with copyright. Is an exclusive right of multiplying, commercially dealing with, and making assignment of copies of work recognized by law as subject period. So let's get into what copyright is first. So for what all for what all do we get copyright? For what all can we claim copyright? Anybody? Anybody?
Drama, cinema, musics.
Does anybody know? Pardon?
A drama, poem, or a cinema, musics.
Yes. So in our day-to-day lives, we've heard it mostly for music, the lyrics of songs, for movies, for books. For all these, we can claim copyright. So do you think it is mandatory to register copyrights?
Yes, ma'am. So there may be a conflict, right? So if it is not registered properly, other people may claim that. Yeah. Hello, ma'am. Your voice is
Okay. So
breaking.
is it mandatory to register to claim copyright? Pardon?
Ma'am, your voice is breaking. I am not sure I am the one who is facing this issue or everyone is facing the issue, ma'am.
Is it still breaking?
Yeah, I am able to hear you, ma'am.
Okay. So basically, we claim copyrights for all these songs, for cinemas, for dramas, for the especially for books. So the moment you start putting your intellect into creating any of these, you actually have the copyright, and it is not mandatory to register to claim a copyright. But the legal procedures would be in the trademarks, as trademarks registration was not mandatory. So is copyright registration. Right from
Ma'am, your voice is still breaking.
put your
Breaking, ma'am.
starting you know
Hello.
okay.
Maybe ma'am, can you
It's
please
actually
disconnect and
raining
connect
here
again,
and
ma'am?
okay.
Oh, okay.
Okay, fine.
No, if you're speaking on mute.
I don't think she's speaking.
Hello, can you hear me? I'm not sure if you can hear. Have been it's raining over here, so it's quite difficult. Just elaborating already. So if my So there is no copyright in live events, and for you cannot copyright. So certain things to which you can actually claim copyright and which you cannot claim copyright. And for example, the lecture which I am taking right now, this even claim copyright. So the lecturers who give lectures in a private, to a particular class where students are enrolled for a particular class, those lecturers can actually claim copyright. But if that particular lecture is made in public, then for those lectures you cannot claim copyright. So there are certain things for which you can claim copyright and for which you cannot claim copyright. So now let's look into what Copyright Act 1957 is. Can you all hear me?
Yes, ma'am.
Okay, good. So the original Act of 1957, the Copyright Act 1957, has been amended in the year 1983, 1984, 1992. These are all the basic things. So it has 15 chapters, 79 sections, and supplemented by the copyright rules, which was also recently amended, not recently, in 2021. So when it comes to copyright and patents, these rights are actually negative rights. So those are not the rights where you get to do certain things. Those are the rights where you get to stop other people from doing certain things. So these are actually called as negative right. It's pretty important when it comes to copyright and patents. Now, coming to section 14. Copyright means the exclusive right to do or authorize the doing of certain acts. It's a pretty very long section 14 of the Copyright Act. In respect of a work or any substantial part thereof, we'll look into it in the next slides. Rights conferred by section 14 upon the author are the economic rights. So there are two types of rights, moral rights and economic rights. Moral rights are actually for the original author, and economic rights can be transferred. It can be initially within the original author itself. Excuse me. After some time, it can be transferred by the from the original author to anybody else, but the moral rights cannot be transferred. When it comes to moral rights, it's nothing but, for example, even if somebody has assigned the copyright to another person, to a third party, they cannot make any changes in that particular copyrighted IP. For example, be it a book or be it even be it a drawing. So we can claim copyrights for even drawings, right? So if the person who has the copyright right now, when after assigning it, if that person tries to change anything, for example, the size of the particular painting or any color patterns or anything, apart from which the original author has amended, anything, if the if that particular third party, if they try to change, that is against the moral rights of the original author. So there are two types of rights, moral rights and economic rights. I hope it's clear. So author of any work is the first owner of copyright, according to section 70. And again, a shorthand writer is not the owner of a work, but the person who dictates is this. So, for example, if somebody writes my biography, and if that person is, for example, he publishes that, he still cannot claim copyright because it actually is within me, because I am the one who dictated it. If I am the one who dictated it, or else if it was, you know, written by observations or something, then it is definitely their copyrighted material. But if I dictate and somebody is writing my biography or something, then the copyright is within me. Now looking into section 14. In the case of, so there are many cases. For example, one, in the case of a literary, dramatic, or musical work not being a computer program, then there is computer program, then there is artistic work, then there is cinematograph, film, then sound recording. So we'll discuss each of it. So what are the different copyrights which can be claimed in the case of a literary, dramatic, or musical work? To reproduce, to issue copies of the work to the public, to perform the work in public, to make any cinematograph, film, or sound recording in respect of the work, to make any translation of the work, to make any adaptation of the work, to do in relation to a translation or any adaptation of the work, any of the acts specified in the specified in relation to the work in subclauses, the above ones. So to reproduce the work, to issue copies, to perform, these are all the rights which are available to the original authors or whoever has the copyright in the case of literary, dramatic, or musical works. In case of a computer program, to do most of the acts specified in clause A. Clause A was this one. And to sell or give any give on commercial rental or offer for sale or for commercial rental any copy of the computer program, provided that such commercial rental does not apply in respect of computer programs where the program itself is not the essential object of the rental. Next, in case of an artistic work, to produce the work, it's mostly the repetition. So to produce the work, to communicate the work to the public, to issue copies, to make any adaptation of the work. So if you have noticed, in case of literary work, you cannot actually see the to communicate the work to the public, right? So in case of an artistic work, they also have the right to communicate the work to the public, to issue copies of the work to the public, not being copies already in circulation, to include the work in any cinematograph film, to make any adaptation of the work, to do in relation to an adaptation of the work, any of the acts. So even for the when it comes to literary works, even they have the right to produce translations or adaptations of the work. So adaptations are generally some sort of inspirations from that particular work. I mean, basically it would be the same, but with minor changes. So in the case of cinematograph film, to make a copy of the film, to sell or give on hire, etc., and to communicate the film to the public. Now in case of a sound recording, to make any other sound recording embodying it, to sell or give on hire or offer, sale or hire, same things, to communicate the sound recording to the public. So these are all basically the rights which are there for these particular sections. Now, in case of work created while not in the course of employment, this is important. The copyright vests in the author. So, for example, if I am an employee of an entertainment company, and then if I have done something before I joined the company, the copyright of that particular intellectual property rests within me. not the particular entertainment company. But if I'm doing something within the course, can somebody mute it? Whoever is on, somebody is in the road or something. Okay, so okay. So while in the course of employment, if I am creating something, if there is an intellectual property I created, then the rights of that would rest within the entertainment company, not within the original author. So this was held in the case of B.T. Thomas alias Toms versus Malayalam Manorama Company Limited. Company Limited. Again, in case of a government work, the government will be the first owner of.
How about the patents, ma'am? How about the patents on the scenario, ma'am?
Patents, we will learn about it. We'll get there.
No, just if I'm working for a company and I'm registering for a patent, okay?
Yeah.
So then it will be considered as for me as an as an individual, or it will go along with the company's name?
Definitely not an individual, only the company.
Oh. Okay.
Unless there is a contract contrary to that between the employee and the company. So unless there is a contract contrary to that, it is already assumed that the patent will be granted to in the company's name. So if you can talk to the company, and if you can draft a contract based on this, claiming that, asking that you want the patent to be in your own name, and if the company also agrees to it, then fine. Unless and until that occurs, it will rest within the company. Am I clear?
Okay, ma'am. Thanks.
Okay. So when it comes to a government work, the government will be the first owner of the copyright. Now, copyright does not subsist in any cinematograph film if a substantial part of the film is an infringement of copyright in any other work, in any sound recording made in respect of literary, dramatic, or musical work, if in the making of sound recording, copyright in such work has been infringed. Now, what are the terms of the copyright? For literary, dramatic, musical, and artistic works, the term is 60 years from the death of the author. Internationally, it is actually 50 years generally. So for photograph, cinematograph, film, and sound recording, 60 years from the beginning of the calendar year following the year in which it is published or released. So these are the terms of copyright. In the case of work of an international organization as declared by the central government under Section 41, copyright subsists until 60 years from the first publication of such works. This is in India. Usually when if you claim for an international copyright or something, it will be usually 50 years. Now, regarding the registration of copyright. Chapter 6 of the Copyright Rules 1956 sets out the procedure for the registration of a work. Registration is not mandatory, as I've already mentioned. Application for registration is to be made on Form 4 as prescribed in the Schedule 1 to the rules. Separate applications should be made for registration of each work. For example, I'll ask you something. For example, for a movie song, let's talk about a movie song. How many copyrights can you see or can you claim in a movie song? Anybody? Can anybody try to answer that?
Can you come again, please, ma'am? How many movie?
In a movie song, how many copyrights can you actually claim?
For the music composed.
For music, yeah, lyrics is one, and music is the other one.
Yes.
Then
so yes, only those two are there. Basically, only those two are there. So for the song, if you get the copyright, you need to get the copyright for lyrics separately itself. So it does not assume that just because you have copyright on a song, you have the copyright for the lyrics also. But again, copyright is again not mandatory. So if when you go to the legal side, it will be easier if the copyright is registered. But still, you can claim copyright for the lyrics even if it is not registered. And again, both published and unpublished works can be registered also. So if you have an idea of a work, and if you have started to work on that idea, again, even if it is not finished, you can still have a copyright. And even if to a finished IP material, even if it is finished and if it is not published, still for that also you can claim copyright. Now let's look into transfer of ownership of copyright. So transfer is usually through assignment and relinquishment, basically. So by assignment, you mean you may assign away 50% or 1% or 99% of your. Basically, you can assign any part of your copyright. You can assign maybe for a particular period of time. So assignment is basically, it depends on your terms and conditions. Section 18 of the Act confers on the owner of copyright the right of assignment of copyright. By operation of law, the transfer of copyright is on the direction of Registrar of Copyrights. The consideration for transfer is also determined by the Registrar of Copyrights as per the Act. By relinquishment is a voluntary act of giving up copyright in a work by its author without expecting any returns. For example, in assignment, you will be actually assigning the copyright for some monetary benefits, right? Whereas in relinquishment, most probably you might not be expecting any returns. The author of copyright under Section 21, Clause 1 is entitled to give up all or any of his rights in copyright by giving prescribed notice to Registrar of Copyright. Now let's look deeply into assignment. Section 19 talks about mode of assignment. No assignment of the copyright in any work shall be valid unless it is in writing signed by the assigner or by his duly authorized agent. So when it comes to claiming copyright, you don't need any registration. You don't need any particular legal procedures to be followed. But when it comes to assigning of the copyright, it has to be in writing. It has to be in the proper way as prescribed by law. The assignment of copyright in any work shall identify such work and shall specify the rights assigned and the duration and territorial extent of such assignment. So you can actually assign the copyright only, for a particular territory as well. For a particular territory, for a particular duration, only for a particular part of the property, and also maybe for a particular percentage of the royalty. So it all depends on the terms. The assignment of copyright in any work shall also specify the amount of royalty and any other consideration payable. Where the assignee does not exercise the rights assigned to him under any of the other subsections of a section within a period of 1 year from the date of assignment, the assignment in respect of such rights shall be deemed to have lapsed after the expiry of said period unless otherwise specified in the assignment. So if you have been assigned a particular copyright, then you also have to make use of it. You have to exercise the rights assigned. So if you don't exercise the rights assigned, it will be deemed as lapse, lapse of the particular assignment. If the period of assignment is not stated, it shall be deemed to be 5 years from the date of assignment. So if it's not mentioned in the particular contract, then a particular assignment, then it will be deemed to be 5 years from the date of assignment. If the territorial extent of assignment of the rights is not specified, it shall be presumed to extend within India. Now, relinquishment, section 21. The author of a work may relinquish all or any of the rights comprised in the copyright in the work by giving notice in the prescribed form to Registrar of Copyrights or by way of public notice. And thereupon such rights shall, subject to the provisions of subsection 3, cease to exist from the date of the notice. So, if you've decided to relinquish your rights, you have to make it public and you have to specify the date from which you actually decide to relinquish your rights. So, from that particular date mentioned in that notice, your relinquishment will come into force. Okay, these are the basic things you need to know about relinquishment. Now let's look into infringement. So according to lay observer test, it's a test which is used to find the infringement in copyright. Whether or not there has been a violation of copyright is to see if the reader, spectator, or the viewer, after having read or seen both works, should be clearly of the opinion and get an unmistakable impression that the subsequent work appears to be a copy of the first. So how do you find if there has been an infringement or not? You take the infringed copy, you take the duplicate copy, and then if you, not duplicate, sorry, if you take the impugned copy, and then when you read both of it, if a normal person, if an ordinary person, if an ordinary reader feels like they both are similar, then it is deemed to be infringed. If to the lay observer, that means the ordinary reader or spectator or viewer, it would not appear to be a reproduction. There is no infringement of copyright in the works. If any of the acts specified in section 14, we did look into section 14 earlier, relating to the work is carried out by a person other than the owner or without license from the owner or a competent authority under the act, it constitutes an infringement of copyright. So if any of the acts mentioned in section 14, all those acts are actually for the person who actually have the copyright, be it registered or not. So it's for the original owners, authors of the copyright. So unless it is assigned, if anybody else tries to exercise those rights, then it will be considered as infringement. So what are the remedies under Copyright Act if there has been an infringement of copyright? The Copyright Act 1957 provides for 3 types of remedies for violation of copyright, namely civil remedies, criminal and administrative remedies. I hope you guys know about the civil remedies. It can be an injunction either, or you can claim for compensation, or you can claim for accounts of profit. If that person who infringed your rights, if they made any profit, you can claim those profits, and you can ask for the delivery of those infringing copies if they have copied. If those third parties have copied your materials, and if they have multiplied those ones, you can actually ask for the delivery of those copies also. And another one is antipillar order. It is nothing but you get an order for search and seizure from the court to just go to the defendant's place and seize the copies without giving them any notice. So you can just go to their place. The court gives you the order to go to the place and just find the copies, the infringed materials. This is to ensure that they don't get the time to dispose of those materials, dispose the evidence. This is basically used in copyrights and patents and stuff. Every suit or other civil proceedings arising under the Act in respect of civil remedies for infringement of copyright in any work is to be instituted in the district court having jurisdiction. Now we look into what are the exemptions under Section 52. So this is a very long section again. You can find a lot of exemptions under Section 52. We'll look into them. A fair dealing with any work not being a computer program for the purpose of private or personal use, including research, criticism or review, whether of that work or any of any other work. The reporting of current events and current affairs, including the reporting of a lecture delivered in public. So, as I mentioned before, for example, this particular lecture that I'm giving you, it is actually a copyrighted material. So nobody can actually use the materials which I use in my lecture, because this is between me and students students enrolled in a particular course. But if I'm giving the lecture in public, then that particular lecture cannot be, I cannot claim copyright for that. And if somebody is using any copyrighted materials for research, those things also you cannot just say they have infringed their copyright. And if they use a copyrighted material for criticism or review, we know there are a lot of literature reviews we can see online. All those things you cannot actually call as infringement of copyright. I hope it's clear. If there is any doubt, please do ask me. Now, the making of copies or adaptation of a computer program by the lawful possessor of a copy of such computer program from such copy for these particular needs, if they make copies or adaptation of a particular computer program in order to utilize the computer program for the purpose for which it was applied, or to make backup copies purely as a temporary protection against loss, destruction, or damage, in order only to utilize the computer program for the purpose for which it was supplied. So I can make a copy of a particular computer program which is copyrighted by somebody else. I can make copies if I have legally bought it from them, one, and I can make copies as a temporary protection against loss of that particular computer program, so that I can use it for the particular purpose for which it was bought. I hope it is clear. Next is the reproduction of any work for the purpose of a judicial proceeding or for the purpose of a report of a judicial proceeding. So these are all exemptions for infringement of copyright. So all these things we cannot consider as infringement of copyright. The reproduction of any work in a certified copy made supplied in accordance with any law for the time being in force, the reading or recitation in public of reasonable extracts from a published literary or dramatic work, in the reproduction of any work by a teacher or a pupil in the course of instruction, or as part of the question to be answered in an examination. So if you actually look into it, we all refer to books for answers. So we write, some people write exactly what is there in the textbooks. So you cannot say that those things are infringement of copyrights just because it has been copied just as it is. And in answers to such questions, the performance of a literary, dramatic, or musical work by an amateur, club, or society, if the performance is given to a non-paying audience. So if the performance is given to a paying audience, then definitely it is considered as a copyright infringement. But if it is given to a non-paying audience, then it is very clear that there is no any monetary benefit that particular person gets from the performance. So those things will be considered as will not be considered as infringement. and for the benefit of a religious institution. All these things will be considered as exemptions for infringement. The reproduction in a newspaper, magazine, or other periodical of an article on current economic, political, social, or religious topics, unless the author of such article has expressly reserved to himself the right of such reproductions. So all these things are exemptions to infringement. Yes, one more. These are not the only exemptions mentioned in section 52. There are other exemptions as well, but I've just added only some because it's very long and it's very, a bit complicated. And one more is the reconstruction of a building or structure in accordance with the architectural drawings or plans by reference to which the building or structure was originally constructed, provided that the original construction was made with the consent or license of the owner of the copyright in such drawings and plans. So if the drawings and plans of a house, they have the copyright, those whoever has drawn it, so they have the copyright for it. So you cannot construct a house without the clear consent from the person who drew the plan. So when it comes to reconstruction of a building, you don't need consent from the person who drew the plan if the original construction was already made with the consent. So if you did not have consent from the person who drew the plan while you did the original first construction of that particular building, you will definitely need consent while you do the reconstruction of that same building if you are using the same drawing. But if you have the consent while you did the original construction, then it is not required. Or else, if you do it, then it is an infringement. I hope it is clear. Does anybody have any doubt on this? I know it is too much information in a very short time. If anybody has any doubt, we can discuss.
No, ma'am, you can proceed.
No.
Okay, fine. Now we look into defenses in infringement. So if there is an infringement of copyright, what are the defenses a person who infringed the copyright can take? Apart from the statutory exceptions listed under section 52, following are the defenses against infringement of copyright. So if you have committed anything mentioned in section 52, then those are exemptions. So those are already your defenses. You will not be charged for infringement. But apart from that, the defenses you can take are absence of copyright in the work alleged to be infringed. So if you can prove that that material actually does not belong to the person who is alleged copyright infringement, then that's also a defense. I mean, if you can prove that copyrighted material, copyrighted property has no originality. So originality is a very important thing when it comes to copyright. So to prove originality, you have to prove that you are the person who has brought it into that particular form, that particular expression, and that it is an expression which does not exist anywhere else. So if you can prove that, and if you can prove otherwise, then it is a defense. If you can prove that there is no originality in that particular work, then it is a defense you can use even if you have infringed that particular copyright of that work. Plaintiff is not entitled to sue, entitled to use or sue. Work alleged to be infringed is not original, as I've already explained. Then work alleged to be infringed is immoral, seditious, or against public policy. Then also it is a defense. The limitation period is, for civil cases you have 2 years, 3 years limitation period. So if you have filed a case after limitation period, then it's also a defense. And another is consent. Consent means if you can prove that it was assigned to you, then it means that, or if it was a relinquished material, then that is also a defense we can take. I hope everything is clear. So these are the things you need to know about copyright as per your syllabus. Do you have any doubts? Okay, I believe you have no doubts. Then we'll take a break for 15 minutes. I'm sorry for taking you know a longer. I might take a longer break because I've been driving for a very long time now. So I'll get back in by 3:20. I'll get back by 3:20.
Sure, ma'am. Thanks.
Thank you.
Okay, ma'am. Thank you.
Ma'am, are you talking on mute, ma'am? Hello?
Yeah, sorry.
Sorry, ma'am, we are not able to hear anything, ma'am. Sorry.
Can you hear me now?
Yes, ma'am.
Okay.
Thanks.
It's actually raining pretty heavy here, so I'll just fast and finish.
Okay.
So we'll look into patterns. I'll start from again. So why do you think, for what all do we give patterns?
Patents can be given for innovation and inventions.
Innovations and inventions. So why do we need to give patents? Why do we need to grant patents?
So otherwise, the work of the particular person may be used by others, ma'am.
Okay, so there is an economical and moral reason behind it. And anything else?
It's
The invention.
securing own ideas or efforts, right? So others should not
Copy that.
Okay,
use it.
securing one's own innovations and
Ideas.
not ideas. We cannot use
Invention,
the term
invention.
ideas actually, but yes, innovations. Then anything else? So unless somebody feels like there is some
Protection.
some remuneration, yes, some reward from one's own innovations, people will not be inspired to do more. So if I invent something and if I make it public, then if somebody else suddenly takes it away from me, then what's the point of inventing another new thing again? So to make sure that inventions keep on coming into the world, and also to make sure that the people who invent actually are benefited from it, we actually grant patents in simple terms. So and patents are not something which is granted for for a lifelong time, or it's actually only for a particular period of time to ensure that the person who invented that gets a reasonable time period to to be benefited from that. And after that, it'll be given to the public, and anybody can use it. And basically, innovations and inventions are something which usually would be beneficial to the public as well. So public should have access access on something, but the
Basically, they have to gain out of something, right? So that is the intention.
Yes, they have to gain out of something. I mean, the gain should be on both sides. The person who invented it also should be gaining, and also the public at large, they also should be gaining. But the public would be gaining it, after giving some
Using
cost.
the product.
Yes, using the product, and making sure that the person who invented it actually gets the monetary benefits from using those products, and only that person gets the profit unless it is assigned or something. Okay, so a patent provides patent owners with protection for their inventions. So we'll look into what the definition of inventions are, and what are the basic conditions for patentability to give a patent, to grant a patent. What are the conditions to be followed, to be fulfilled? All those things we'll be looking into. Protection is
the
granted
discovery cannot be a candidate for the patent, right, ma'am? Or
pardon?
Discovery. The discovery is not considered to be a patent, right?
Yes,
Not
yes. Discoveries will not come under invention. So there are certain things which cannot be patented. It is mentioned under section 3. We'll look into that.
Okay.
So protection is granted for a limited period, generally 20 years. In return for patent protection, all patent owners are obliged to publicly disclose information on their inventions. So if the patent is not granted and if it is disclosed, if that particular invention is disclosed, then anybody can use it and anybody can commercially, industrially apply it and make, monetary benefits out of it. So to make sure that does not happen, you give patent protection. So that the technical knowledge of the world is also enriched and also the person invented it is also getting benefits. Patent protection means an invention cannot be commercially made, used, distributed, or sold without the patent owner's consent. The application also contains various claims. So when you look into the application for a patent, there are different parts in that particular application. The application form, I'm saying. So there would be a claims part, there would be a specification part. So the claims part would be the the highlights of the application form, the main things for which you are applying patent. And the specification part would be the extra details to the claims. And there can be two types of applications. We'll look into all those things. So now we'll look into what the conditions of patentability are. One, the subject matter should be patentable. It should be it shouldn't be anything illegal. It should be something useful, and there should be an industrial applicability for that. So it should not be something which cannot be industrially made or which will not be used by the public. If it doesn't have any application, then there is no point in having it, right? Then there is no point in granting a patent, because if nobody is going to use it, then, and if it cannot be produced, then there is no point in having an invention. And there should be novelty. It should be new. It shouldn't be known to a prior user, or it should be known to someone who has already been in that particular technical field. So it should be new to even people in that particular technical field also. So those people also shouldn't have any idea. I mean, the other people in that same technical field shouldn't be having any idea about these novel inventions. And there should be an inventive step or non-obviousness. It's the same. And the specification. Now we look into what an invention means according to the Patents Act. Section 2(1)(j) talks about invention. Invention means is rain being a distraction to you? It's actually a distraction to me. My voice.
We couldn't hear you properly at times. So too feeble.
Yeah, it's actually pretty. It's raining pretty hard here. It's difficult for me to take as well. So yeah, I'll just elaborate on what is there on the PPT. So if you have any doubt, just let me know from reading the PPT. So invention means involving an inventive step and capable of industrial application. So invention, according to the definition of invention according to Patents Act is something which involves an inventive step and capable of industrial application. Now, inventive step, what do you mean by inventive step? That involves technical advance as compared to the existing knowledge. So some kind of an advance, when you compare to the existing knowledge in that technical field. Or so it can be an advancement, or it can be having economic significance. So it can be something which adds hugely to the economic significance, or both. So it can be both and also. So there has to be a technical advancement, or it should have an economic significance, and that makes the invention not obvious to a person skilled in the art. So in that particular field, those people who are skilled in that particular field, they shouldn't be aware of this particular inventive step or this particular invention. So it shouldn't be already existing in the market. Okay. Section 3. Inventions not patentable. So which are the inventions to which patents cannot be granted? So some of them are inventions contrary to law and order. So if law prescribes that, law of that particular nation prescribes that these things cannot be patented, these things cannot be invented, then that's it. You just cannot have patent to that particular invention. An invention, the primary or intended use or commercial exploitation of which could be contrary to public order or morality, or which causes serious prejudice to human, animal, or plant life, or to the environment. So when you grant patents, all these things will be taken into consideration. So if it falls into any of these, then patent will not be granted to those. And so, as somebody asked before, discoveries cannot be patented. So if you just discover some new type of rock, which already exists, so rocks are something which already exists in the nature, right? So if you find a particular rock which nobody else has discovered ever, it cannot be patented. It's just another form of discovery which already exists. There's this sound from
how come the mathematical formula doesn't seems to be a patentable, ma'am? So it may be a kind of a new formula. So on the point 3, ma'am, discovery scientific theories mathematical formula, right? That is what mentioned, right? On this, on this mathematical formula, right, ma'am? So if I am trying to do, I mean, some innovation on creating a new formula, okay, then why it is not patentable, ma'am? Is there any reason, specific reason?
Yes, there is no any specific.
It's not existing, which is not existing in the world, right?
It is not existing in the world, but it has been formulated using the already existing, number system and all those things, right? I mean, anybody in the particular skill could foresee that particular thing, right? There is a probability for anybody who's already existing in that particular field to foresee those things, because any mathematical formula would be using pre-existing formulas, or I don't know the technical terms to be used for explaining this, but there is no any particular explanation given in the act on this. But I think it'll be difficult to explain why mathematical formulas, for example, the okay, we'll take another thing which cannot be patented. It's the way of treatment in the medical field. So the way of treatments, the therapeutic methods, surgical methods, these things cannot be patented. Why do you think it cannot be patented? People are putting their intellectual. Yeah.
But the procedure is already there, right, ma'am? There are serious steps that has to be followed for any surgical procedures and all, and these are all documented earlier as well. It's not kind of a new innovation or something, right? Or a new invention,
yes,
right?
But what if
the
somebody,
way that they do,
what if
the
some,
way that
what
they.
If somebody?
Sorry, ma'am. No, the way they do,
so
the way it may differ. The person to person, it may differ, but we cannot say that it is a kind of a new invention.
No, sometimes there are people who find new methods to treat a particular disease. There are.
That is true.
And I'm not sure. Yeah, so even that cannot be patented, because these are certain things. If patented, it will be difficult for the public to access. These things are very, for example, if that mathematical formula is not, if it is patented, then it will be very difficult for people to use. And also, mathematical formulas, maybe, I'm not sure, it can be formulated. So I think we can have a discussion on that after I maybe learn more about it. Or if anybody has any, if anybody has any, inputs on that, you can, please feel free to talk. So, or else I'll look into it more and speak to you in the next class.
Okay.
Okay. So the mere discovery of a scientific principle or the formulation Okay, maybe mathematical formulas, industrial applicability is also a condition to be fulfilled in case of inventions. And surgical methods, all these things, I'm not sure how far the industrial applicability can be explored. So when it comes to a patent, the basic things are, it should be novel, obviously, and it should be industrial. There should be some industrial application for that as well. So there should be a commercial purpose for that as well. So a mathematical formula as such does not have a particular industrial applicability. Just if you take the particular just formula itself, or if you take a particular surgical method itself, there is no industrial applicability. These things, when it comes along with the medicines, along with the people, along with all other things, only then it contributes to some commercial exploitation and industrial applicability. But when it comes to theories, formulas, all these things together with something else, it constitutes to some commercial exploitation. Otherwise, in its unique, in its individual existence, it does not create any commercial exploitation. I hope it is clear. Is it clear?
Yeah, ma'am. But why I'm curious, ma'am, because they are talking about the mathematical formula. Again, if you think about the chemical formula, it is patentable, if I'm not wrong, right?
Chemical formulas as such, I don't think chemical formulas are patentable, but if you can find a new chemical or something, then it can be patented.
It's not a new chemical. Using some chemicals, we are creating new. I mean, we are creating new products, right? We are, forming new
drugs or some
drugs, new drugs.
Yes,
Yes,
those things can be patented. And when it comes to drugs also, if you just for example, if you make minor changes to the drugs and try to get a new patent for that, that also cannot be patented. So yes, chemical formula as such cannot be patented, but the result of that chemical formula, those drugs or something, whatever it is, those things can be patented if it has a commercial exploitation value. Okay, I hope it is clear.
Yes, ma'am. So for mathematical formula as well, ma'am, they are saying that
it's not patentable, right? It's not patentable means somebody can adapt to that base and they can develop, right? It is not, no one can claim it actually. So they can get the fundamentals of that particular innovations and they can do their own way or find progress on their own way. That is the reason these are like not patentable. It's patentable only you will not get more things, right? So not patentable means then we can use more, right, based on that one. It's a kind of development, right? So that is the reason they categorize as not patentable. Something patentable means also, you will not progress, right? So anyone can claim, which some of the product invented in 1850s, right? There could be a constant progress or some additional thing, incremental things may be there, but a base can be the same. So that is the reason this has been not patentable.
Exactly. That is
but
also
again, if you see the mathematical formula, it's still patentable if the formula has been applied.
Yes, after applying the formula, you have found something, right? You cannot just
correct.
See the formula in as such cannot exist as a commercial. It does not have some industrial applicability as such, as just a formula. If you take just the formula itself, it doesn't have a commercial application. But use the formula and create something, then if
patentable, then it is patentable.
Yes, that particular thing can be patented. Is it clear?
Got it, ma'am. Thanks.
Okay, fine, very good. So the mere discovery of a new form of a known substance which does not result in the enhancement of the known efficiency of that substance, or the mere discovery of any new property or new use for a known substance, or of the mere use of a known process, machine, or apparatus, unless such known process results in a new product or employs at least one new reactant. So I hope that sentence in itself is clear. So even if you discover a new form of known substance, if it doesn't improve the efficacy of that particular existing substance, then those things also cannot be patented. Then aesthetic creations, plans, principles and methods, rules of games, all those things cannot be patented. Information computer programs as such cannot be patented, but you can claim copyright for computer programs. I hope you know that. But computer programs, when you apply it, and results in something, those things together can be patented. Computer programs as such individually cannot be patented. Animal species, plant or animal production processes cannot be patented. Surgical or therapeutic methods of treating human or animal bodies and methods of diagnosis cannot be patented. So now we'll look into some of the international treaties when it comes to patents. One is the PCT 1970. In September 1966, the Executive Committee of the International Union for the Protection of Industrial Property invited BERPI, which was a predecessor of WIPO, to undertake urgently a study of solutions to reduce the duplication of the effort both for applicants and national patent offices. So there was this Paris way of getting a patent, and there was this PCT way. So when it comes to the Paris route, it was like you get the patent internationally, but you will have to apply to each nations individually. But when it comes to the PCT, you can just apply from the original country, and then you'll get a international recognition as well for all the contracting states, for all the contracting countries. So you can save on a lot of money and time when it comes to claiming patents, of applying for patents internationally. So as I've already mentioned, there are two ways through which you can claim patent internationally. One is the Paris way. So file local application. Local application is from the particular nation from which the you apply first, and then file applications abroad separately for each country. And the PCT way is file the local application first, then file the PCT application within 12 months, and there will be an international search report and written opinion. Then there will be an international publication. So for even in the national patent application, there will be you apply for it, you apply for the patent, and then there will be a search. There will be a publication. I mean, it will be open to the public, and you can actually the people, if they find it infringing to the existing patents or something, they can actually report it, and then if everything goes well, the patent is granted. But still, it will take a pretty long time, 2 years, around 2 years to 2 to 3 years, maybe 1.5 to 3 years to actually receive a patent. Here you can actually go through this one when you have time. This is not really important, but I just added for an additional information. Now there is the Geneva Convention on Patent Law, which was formed in 2000. A set of formal requirements for national and regional applications was standardized by incorporating into the PLT the requirements relating to form or content of international applications under the PCT, including the contents of the PCT request form and the use of that request form accompanied by an indication that the application is to be treated as a national application. This eliminates or reduces procedural gaps between national, regional, and international patent systems. So, to ensure that when you apply at the local level, you also get the national level patents, and after which you'll be receiving the international patent as well. When it comes to the Paris rule, it was like if you apply to multiple nations, The priority date. The priority date is determined based on priority date. I've already, I think I've explained it in the last class. It's the date when you apply for the
Date of submission.
Yes, date of submission of that particular application. It can be a full application or it can be a provisional one. So when you submit that, based on that, the priority date would be fixed. So when it comes to international application, the date in which you applied in the first nation, the original nation, the original state, that date would be considered as the priority date. So when you apply in other countries, you get a shorter waiting period, for receiving the patent, because the priority date will not be the date of application in those abroad, those nations, those other nations, but the original nation itself. So you'll get an earlier priority date. Now let's look into the Patents Act 1970. It came into force in the year 1972, amending and incorporating the existing laws relating to Patents and Designs Act 1911 in India. Section 3D introduced into the said amendment Act 2005 and introduces pharmaceutical product patents in India for the first time. And in India, there are two types of patents which are granted. One is product patent and process patent. So even for processes, you can actually claim patents. Section 3D introduced into the said Amendment Act. Yeah, I've already covered that. The Act consists of as many as 162 sections. And there is this Novartis case, which is very famous when it comes to patents in India. So there was this chemical compound called imatinib mesylate. In Indian patent law, represents a major victory for communities' access to inexpensive medicines in developing countries and influences the access of medicines to the poor. So, what the pharmaceuticals do is, usually what they do is they try to improve those existing medicines by, adding some chemicals or something. And there would be a very, very, very slight changes, and that is not just good enough for getting a new patent. So if you have just made slight changes to that existing substance, then you cannot have patent. That was actually clearly mentioned in the Novartis case. They tried to change the substance. It did not make any major change in that existing substance, so it was not actually granted. So to make sure that the pharmaceutical companies don't take advantage of the patent system, this was actually held. Now, something which is there in your syllabus is software and business method patents. So in general, it is a patent relating to a method of doing business. So, as you know, for products and for process, we can claim for patent. So for a method of doing business, there is a patent called as software and business method patents. This includes new types of e-commerce, insurance, banking, and tax compliance, etc. So Amazon's one-click shopping was something which was, granted a business patent actually. Business method patent, not business patent. Excuse me. So patented a system that allows consumers to purchase items by clicking the order button on a website. So these are some of the, this is one of the example for business method patents.
Process, right, ma'am?
Yes.
Just for
yes,
process.
Yes. Yeah, business process patent. According to Section 3K of the Act, a mathematical or business method or a computer program per se or an algorithm is not patentable in India. The term per se is not defined in the Act. However, the computer-related inventions guidelines of 2017 indicate that the term per se should be interpreted based on the general dictionary meaning. As per the general dictionary meaning, per se means by itself. In other words, a computer program by itself is not patentable. So that one word actually, opened the way for computer programs also to be patented. So if that computer program has some industrial applicability, not by itself, by adding something also to it, then those things can be patented. So business methods can be patented. I hope it is clear. Now we'll look into infringement. So infringement, nothing much is actually prescribed in the acts, more on what causes infringement. So okay, we'll look into it. So the Supreme Court of India has laid down the following guidelines to determine infringement of a patent based on this case, Viswanath Prasad Radhesham versus Hindustan Metal Industries. So we'll look into that. Read the description and then the claims. So these are the guidelines to determine infringement. So read the description part, then the claims part. I've already mentioned that in the application form there are these parts. Find out what is the prior art. So what knowledge existed on this particular technicality in that field. What is an improvement over that prior art? So what is that exact improvement which has occurred based on that particular prior art? List the broad features of the improvement. So what are the improvements? What are the industrial applicabilities? All those things you have to ascertain. Compare the said broad features with the defendant's process or apparatus, and if the defendant's process or apparatus is either identical or comes within the scope of the plaintiff's process or apparatus, there is an infringement. So while determining infringement, you have to see what are the claims are. You have to look into what the prior art which already existed was, and you have to see what are the improvements over the prior art was. And if you find similarities, then obviously there is an infringement. I hope it is clear. So now we'll look into what some of the defenses are. So the defenses are mentioned in section 107 in suits for infringement. In any suit for infringement of a patent, every ground on which it may be revoked under section 64 shall be available as a ground for defense. In any suit for infringement of patent by the making, using or importation of any machine, apparatus of other article, or by the use of any process, or by the importation, use or distribution or any medicine or drug, it shall be a ground for defense that such making, using, importation or distribution is in accordance with any one of or more of the condition prescribed in section 47. You can actually refer to those sections. The defenses are actually not too important, but yes, you can just go through it. Certain acts not to be considered as infringement. For the purposes of this act, any act of making, constructing, using, selling, or importing a patented invention solely for uses reasonably related to the development and submission of information required under any law for the time being in force in India or in any country other than India that regulates the manufacture, construction, use, sale, or import of any product. Second is importation of patented products by any person. A person who is duly authorized under the law to produce and sell or distribute the product shall not be considered as an infringement of patent right. So if you have the right to do it, you can actually you cannot actually consider it as an infringement. So what are some of the defenses you can use in a suit for infringement? So they are: plaintiff is not entitled to sue for infringement if you can just prove that the patent does not belong to that particular plaintiff. You can use that as a defense. The allegation of infringement is false if you can prove that there is no infringement occurred by. Maybe you can prove through way of tracking the prior art and proving that the advancement to the prior art is different in that particular invention and is different in yours, then that was also a defense you can take. And there was permission or license to use the invention. The principle of estoppel or res judicata is attracted. The claims alleged to be infringed are valid. The existence of a restricted contract is declared unlawful. For example, if there has been a restricted contract, that existence. contract is declared unlawful. Yes. So if there has been a contract which restricts the use, then that also can be found as a defense for the infringement. Then the act complaint is covered within the scope of innocent infringement or done after a lapse of the patent. So if you can prove that it has been an innocent infringement, and then you still will have to pay the damages and stuff, but to only a reasonable extent. And then if you can also prove that it has been done after the lapse of the patent, I mean, that is 20 years. The maximum period for which you will be granted a patent is 20 years. So initially it will be granted for maximum 2 years, I believe, and after which you will have to renew it. You can renew it to maximum 20 years. So if you have not renewed it, that also can be considered as a lapse of the patent. So if you renew it, then okay, you still have the patent. If you've not renewed it, even within 20 years, anybody else can use that. The alleged infringement of the patent, which is not novel or it is obvious. So if you can prove that even after the patent is granted, if you can prove that it is not a novel invention and that it is obvious to the skilled people in the technical field, that also can be used as a defense for infringement. Okay, so these are all the main things you need to learn in patents as per your syllabus. Any doubts? Does anybody have any doubts?
Okay.
Okay, I hope everything is clear. You have only cyber law to be covered. That will be covered in next class, or else it will be just too much. So we've finished trademarks, IPR in general. We've covered copyright and patents. Now only cyber law is left. So if there is any doubt in any of these topics, you can ask now, or else we'll wind up the class. Is there any doubts?
No, ma'am, it's clear.
Okay. So we actually covered all the syllabus. So if there is any doubts, you can reach out to me. We'll stop the class. We'll conclude the class.
Yes, ma'am. Yes, ma'am. Okay.
Oh.
And will the PPTs will be shared to us, ma'am?
Yes, I'll be sharing it after the class is over. All the classes are over.
Okay, ma'am. Thanks.
Thank you.
Thank you.
Thank you.
Yeah, thanks, ma'am. Thank you.